Okay, a very pleasant good afternoon to everybody, and welcome to another episode of BHBA Family Law Presents Direct Examination with Dan and Lauren. Along with Lauren Youngman from Youngman Reichstein, I'm Dan Bemmel, financial advisor and certified divorce financial analyst. During each episode of our show, we explore our guest's personal and professional history and dig into a meaningful legal topic. Please continue to join us for our upcoming episodes, always at 12:30 p.m. live on Zoom. Judge Scott Gordon on April 12th, Stacey Phillips on May 3rd, Grace Jammer and Michael Hanesab on June 7th, with Aaron Gray and Chelsea Stevens, Judge Harvey A. Silberman, and more later in the year. Lauren.
Good afternoon. You will receive your MCLE certificate shortly after the program. Please take a moment to complete the survey that's included with your certificate. The Family Law section is sponsored by White, Zuckerman, Warsofsky, Luna, and Hunt. White, Zuckerman, Warsofsky, Luna, and Hunt provides a wide variety of resources to complete almost any project, large or small. They also provide traditional accounting and tax practice services. We invite you to contact them to discuss your specific accounting needs and learn how they can be of service to you. That's it for our sponsor.
Okay, well, today we welcome Glen Schwartz. Glen is, of course, most well known as one of the parents of modern parentage law, taking cases all the way to the Supreme Court. Of course, we'll get into that, but Glen's career and practice encompasses an incredibly wide range of experiences across a number of disciplines, and he's seen just about everything there is to see in the law since he was first admitted just last week in 1974. So we have a lot to get to today, but first, Glen, thank you so much for being with us.
Well, first I want to thank Lauren and you, Dan, for having me. It's really a privilege and an honor to be here with you today. And let's go up. The parent of modern litigation. Let's just say I'm an enthusiast. My children, Adam and Lisa, wouldn't really go for I'm the parent of paternity litigation or parentage litigation.
Okay, well, we'll get to that. We'll let everybody else decide at the end of the day.
Everyone can make up their own mind about that.
Okay. Yeah. That's not for any of us to say, I guess. That's fair. But I do want to start out. I want to get in a time machine here and meet young Glen. I want to start there.
I'm still young Glen.
Slightly younger Glen. And really just ask, when did you know that you wanted to be a lawyer? It's such a calling. When did you hear the call?
You know, Dan, Lauren, I've always wanted to be a lawyer. I don't remember a time in my life, even as a young kid, when I did not want to be a lawyer. I can't tell you where that comes from. My dad there was no lawyers in my family. My dad was not a lawyer. We didn't even know lawyers. It was just something innate that I just felt I wanted to do. And my path kept taking me in that direction, as we'll discuss throughout this session. So
what was that family dynamic growing up? Like, your dad wasn't a lawyer. What was it? What did he do? What was the family's background?
My dad was an immigrant and he was a blue collar worker. My mother was for the most part, a homemaker. I had an older sister. And again, there was no legal component to our family whatsoever. So I grew up here on the west side of LA. Went to Hamilton High School for high school, and so I just always felt and knew I wanted to be a lawyer. Never deviated from that desire and path.
How did you first become aware of the law as a possible career path even?
You know, it's hard to remember. I was always fascinated with, the high profile criminal cases at the time. The Charles Chessman case, which was, and for some reason, I was fascinated by the Leopold and Lowe case that took place much before my time, and even the Rosenberg trial. These go back some time, but those legal cases always has fascinated me from a young age.
So you're following all this stuff in the paper and on the news, the Clarence Darrow type of stuff.
Right.
What were you actually doing back then? I know that you were working as a kid. What were those early jobs like?
I worked from an early age, started, of course, like many of us, with a paper route when on my bike delivering papers. And I worked in the student store at my junior high school. And then throughout high school, we called it back in those days, a box boy throughout my high school years. So I always worked. I always had a job. I come from a family, my dad had an incredible work ethic that he instilled in us. And I think I've instilled in my kids as well. They seem to have it.
When you started thinking about college, did you think about leaving LA or did you always want to stay local?
Always wanted to stay local. It was more affordable as well. My family was not a wealthy family. So we looked for the best deal, though ironically, I ended up at USC.
I was just about to say. And so how did you land at USC?
Well, my dad, again, as I mentioned, was an immigrant. And when he came to Los Angeles, he and his father were fruit vendors, literally pushing a horse in a cart. And he would hang around USC in those days. That's where that was the university. And he hung around to pick up girls was the real reason he was there. But he just had this desire. He couldn't go to college. And he wanted his kids to go to college, and he wanted his kids to go to USC.
I love that. So late high school, late 60s, into college in the 70s, and law school, obviously, in the 70s. We'll get to that. But what was it like in LA? Tell us a little bit about the political environment, the social environment. What was going on in the city, and how did that impact you?
You know, Dan, it just seems like in the 60s, pretty much I was pretty self-absorbed in high school, trying to get through high school, dealing with the typical, teenage problems, thrilled to save up and get a car from working.
What was the car? What was the first car?
Well, the first car I had was, believe it or not, a Impala convertible, a red Impala convertible, which I bought secondhand. And then the first new car I bought was a VW Bug for all of $2,500 right out of the showroom door.
Love it. Okay, so you're driving your Impala, you're driving your Bug around LA. What else is going on? Did the political environment at the time have an impact?
Not a great deal on me, I must say. I was pretty consumed with school, getting through those problems at school that we all have, that I had at school, just getting through. So was I politically active in those days? No, I was not. I was more.
So then what was your social life like, in high school, into college, studying hard? How did you find your way navigating the social cues of high school back then?
I think I figured out quite early that high school survival in high school was to be part of the in-group, which I certainly was not. But I worked hard to become in the in-group, and at least on the fringes of it. And that's how I perceived the way to survive high school. We had 700 people in our class, I believe. It was a big high school. And so by being involved in student government and things of that sort, I was student body vice president, just being involved in the politics of the school and trying to be part of the in-group, which I don't think I ever was, but maybe tolerated in the group. Just that's how I got through high school. That's my high school experience. There was a bunch of very smart kids who went to Hamilton High School back in the late 60s. And I was not in that group. In
But at the
fact,
same time, your classmates had something to say about who you were, right, when you graduated.
yeah. My claim to fame at Hamilton High School is in my senior year, I was voted happiest and friendliest.
I love that.
Now, I know my son is listening to this and he's still laughing because a number of years ago, he found my yearbook. And was sitting on the couch. I remember distinctly. He went, "You were happiest and friendliest?" I said, "Yes, Adam." He goes, "That must have been a bunch of very depressed, nasty kids."
All right. So end of high school, you're getting ready to go to college. What was the thought process there? You talked a little bit about dad and wanting to go to a school here and the price, but how did you end up at SC?
Well, first of all, I had a counselor in high school, remember his name, Mr. Miller, who told me I was not college material.
Oh, Mr. Miller's watching. Let's bring him on right
Yeah.
now and see.
I hope he is. Mr. Miller, who told me I was not high school material and I should look for a vocation. I obviously did not pay much attention to Mr. Miller and went on to USC, was able to get, my grades were sufficient. I always was able to keep up, maybe through some good-hearted teachers, the necessary grade average to be in student government. So based on that, I was able to get into USC.
What was your experience like at USC? Did you work while you were in school?
Yeah. Yes, I was very fortunate. I got a job on campus at the USC Law Library, where I worked for 4 years. It was a perfect job for me because I would take classes in the morning, schedule my classes in the morning, and then drive the bike over to the law school and work in the afternoons. I worked about 20 hours a week. So for 4 years, I had the benefit of being in the law library, just being part of the law school and part of the law library. Very good at doing loose leaf services. I must tell you, I can still do those quite well.
I don't think they do those anymore.
That spent hours of my day and just being around the environment, the law school environment, and the other law students who I came to know. That just kept me on the path of, I want to be a lawyer. Everything worked that way. So for 4 years, I worked at the USC Law Library.
So what else was going on? What did you do kind of outside of that class work cycle? Obviously football games, I would assume back then.
Yeah. So
right.
I spent a lot of time studying for reasons we'll talk maybe in a moment. I had to spend a little more time than most students studying and transcribing notes. I would tape record my classes. I was with permission, and then I'd spend the hours just transcribing my notes. So I spent a lot of time, maybe more than most, studying to get through. Football games, and then there was 2 summers there. I took off and backpacked through Europe by myself. That was a wonderful experience. Spending, time just wandering Europe, learning the art of traveling, learning the art of self-confidence, and how to take care of yourself and how to interact with people you may not know. I think that boded well for me throughout the years in being able to follow the path, as we'll discuss, of being a sole practitioner for all these years.
So after college, did you go immediately to law school, and where did you land?
I did. I went immediately to law school. I landed back at USC. It was a choice. I was accepted at UCLA and USC, and it was a tough choice. But I was comfortable at USC. And in those days, the first year class was much smaller. I was comfortable in the school. I know that I think I'm still paying off at law school. But I ultimately chose to stay at USC and went to USC Law School.
When you decided to go, obviously it sounds, we've talked a little bit, it sounds like it was almost destiny from the beginning. Did you have a particular focus? Did you know what you wanted to do on the way in?
No, I don't recall having a particular focus. I think I was just thankful I got into a law school.
Okay, so take us there. What were those first year classes like, and what was your initial experience?
Well, at USC back in those days, they were teaching it. Maybe they are still today. The Socratic method. It was terrifying. It was terrifying. You would go to a class and just hope to God that the professor did not call upon you. If you were called upon at the beginning of the class, you were there for a whole hour being humiliated. Because the whole concept is there's no right answers. So even if you were given a right answer, these professors would say, no, that's a silly answer. And it went on and on. I remember back in those days, the movie Paper Chase that many of you have seen was on. And I watched it and thought, that's easy compared to what we're going through. That wasn't that bad. But the first year was really tough. I think most law students, most lawyers now could identify with that first year. And it got easier and easier.
Were there any professors that stand out either on the paper chase side or on the supportive side?
All of them stand out.
In the nightmares, I guess.
I still have nightmares about them. I remember years later, a few years back, Professor Howard Miller, who himself went into politics. He was a very smooth, articulate professor, immaculately dressed and just terrifying. A few years back, I was asked to be in a panel do an ethics seminar, and Howard Miller was on it. And so I got a phone call one day here at the office, and it was announced Howard Miller's on the line. And the first thing I said to him, I said, Dr. Miller, just picking up the phone, hearing your name, I've broken into a sweat. and he laughed. And I said, no, I'm not joking. I'm really nervous talking to you. But it worked out fine. We did a couple programs even after that together.
Well, you somehow survived the harsh USC law school. And what was your plan as you wrapped up and were preparing to take the bar?
Well, the plan, like everyone else, was to get a job after I took the bar. But first we had to take the bar. I remember when we graduated USC Law School, we got this very large diploma still on my wall. And I was living at that time in a small apartment in Venice. Don't misunderstand when I say Venice. It was not the Venice that people recognize today. In fact, my mother would always be ashamed that I lived in Venice. Her line was, would she tell people, where's Glen live? He lives near the marina. She could never bring herself to say he lived in Venice. But I had a small apartment in Venice, and I put that plaque on the heater. I had a wall heater, so I couldn't miss it every day. And I'd look at it, and the thought was, if I don't pass the bar, that big plaque is worthless. So I studied every day for the bar, and did luckily pass it the first time, so I didn't have to take it again. And then, so the concept was obviously get a job.
Did you do anything exciting between those two, between passing the bar and?
Yeah, Dad. The night after I took the bar, I went to my closet, got my backpack, that I traveled with throughout Europe, and went down to the Greyhound bus station downtown, took a bus to the border, walked across the border, took a train, 30-hour train trip to Guadalajara, and then wandered Mexico for a month, and then came back, and then said, okay, it's time now to get serious and get a job.
This is awesome. Between the Europe travel and going to Mexico, it's like a vision of you as a samurai wandering the earth, basically.
Just a small guy with a big backpack on my back.
I love that. So when you got back and had your ticket, what did you do?
Well, I had a pretty good resume coming out of USC. Yeah, of course, my memory today is I was at the top of the class, but really in reality, I probably was very much in the middle of the class. But time does that to our memories, doesn't it? But I had a pretty good resume. And as we do from law school, we start to apply. I think this may be a good point to discuss something a little personal, more than a little personal. The viewers could see I have an impairment of sorts. I have, which I don't talk about, but let's talk about for a moment. It'll put everything in perspective. I have a congenital, meaning from birth, disorder of the nervous system. It's never been precisely diagnosed what I have. It's just who I am. I've always had it. It's non-progressive. I'll always have it. It's just, to my mind, it's who I am. It's not particularly in my consciousness on a regular basis. And I don't define myself nor want to be defined by my impairment. Unfortunately, when I started to apply for jobs, other people wanted to define me by my impairment. So I would get in the door maybe for some of these firms who are hiring, and like my resume would call me in, but those interviews lasted lasted moments. It was out the door very quick. I would get a comment, the gist of which was, "You're really a qualified, great guy, but we're not sure the clients would be comfortable with you." So, after one or two, maybe top three such interviews, where I was, don't even bother sitting down, Glenn. Let me just get to the point. I realized that was not going to be my path into practicing law. Those rejections basically just motivated me. I've always dealt with rejections as motivation. I feel that's the way to handle it. So I realized if I'm going to practice law, I'm going to have to do it by myself. I found a storefront in Westwood Village. A retired judge, quite on in his years, had a couple of offices right on Glen in Westwood Village. And I convinced him to let me have one of these small offices up front. And if he needed any legal work done, I would do it for him. Fortunately, he didn't need much. And I just opened up hung my own shingle, as the expression goes. And
so Glenn, just to cut in real quickly before we definitely want to explore what that was like hanging up your first shingle, but I just want to go back a little bit to some of your comments about your condition. Have things changed over time from when you had those first interviews, or whether it has to do with judges, opposing counsel, clients, or is it largely the same?
Well, I'm not interviewing. For the most part, I sense that I'm not defined by my colleagues and by the judicial officers. As an impaired person, I don't perceive myself as such. My presentation in court, I've worked on through the years, may be a little more animated than most. But I think sometimes that's entertaining. Entertaining, and we keep our humor. One thing that's always got me through life is humor, and the sense of humor. I've always enjoyed being in front of good judicial officers who have a little sense of humor. And you could say something to them and maybe they'll crack a smile.
So back to this. Oh, go ahead, Glenn.
For those little older lawyers who may be listening, there was a judge, a wonderful judge, Judge Denner, who sat in family law for years. And he was a very stern guy, but I got to know him quite well because I was chair of the family law section when he was supervising judge. So we would go out and speak often together. And if you could picture this, since I'm telling the story, it's Judge Denner was a former football player of college. He was generally, I'll say about 6'5", weighed probably over 300 pounds. Just picture him standing next to me. I always felt like I was standing next to a Disney character. You know, the little kids at Disneyland stand next to Goofy. That was always the feel. And Judge Denner always liked to do short jokes. He would always do short jokes. So we would go out and speak, and his favorite one was he would stand right next to me and look around and say, in a voice, he had a deep voice, "Has anyone seen Schwartz?" But again, and my goal every time I was in this courtroom was to say something to see if I could make him smile. And I've done that with many a judicial officer.
I like that. It's your own like Abbott and Costello routine.
It was. We were sub-team when we went out to speak together.
So take us back. You're in this storefront on Glendon, hustling. How did you first start getting those cases? The work. How do you pay the bills?
There weren't too many bills, thank God.
Well, you got to eat.
Yeah. Well, what I did is, I immediately, my first client was the phone man who was installing the phone in my office. And he said, "My wife was just in an automobile accident. Do you do that?" I said, "Do I do that?" So there was my first case. A gentleman who was working around the building construction, a little construction and gardening, came in one day and explained to himself he's from El Salvador, and his entire family was with him. And he says, "Do you do immigration work?" I said, "Do I do immigration work?" Always giving the rhetorical answer. And immediately I started to study immigration law, personal injury law, and was able to handle those type cases. That signing up with as many bar referrals systems that I could that would send me cases or potential cases. I remember Santa Monica Bar Association used to have a nice attorney referral service, LA County Bar. So I would do those type of things, and get work wherever I could. And if I had an opportunity, I'd go speak somewhere. I remember I would, the Hollywood Free Clinic. I always like to have a guest speaker. I would speak oftentimes at the Hollywood Free Clinic as a guest speaker. And whatever it took, I would do and figure out how to do it once I got it.
What about your work with the Court of Appeals?
Thank you for reminding me. Throughout law school, I learned how to do criminal appellate work. Some guy had a mill, and he hired certain lawyers just to do the work. So throughout law school, in addition to law school at night, I would work in the law library, reading transcripts of criminal cases and writing appellate briefs. Really a frightening concept when you think about it. You have a first year, second, last 30. just looking up and trying to spot the issues in transcripts of some significant cases and writing briefs, which
It's like getting a surgery at a teaching hospital.
it was really frightening to think about. I continued to do that as well when I opened my practice, though again, that path wasn't well. I had done by graduation of law school, I had done, a few dozen cases and knew how to do it quite well. And I remembered when we were sworn in for the bar, the head clerk of the California Court of Appeals, Second Appellate District, swore us in. I won't repeat his name for the moment. And he said to all of us who were sworn in, if there's ever anything I can do for you, give me a call. That foundation to this story. So now I open my own storefront. I want to do appellate work. To tide me over. The pay was terrible and it took forever to get paid. So I went down to the Court of Appeal in the clerk's office where all the clerks from the various, at that time, 5 divisions were. And I went in and someone came, one of the clerks came up to me and I said, I would like to be appointed to do some appellate work. I've had good experience doing it. And I can still picture that gentleman today. He basically laughed at me and said, "No, we don't give it to new lawyers," and sent me away. Well, what I did was I went back home, picked up the phone and called the head clerk who spoke at the ceremony.
He offered it.
He offered it, and for some reason I got through to him and I explained to him, "Sir, I came down, I asked for to be appointed to do this work. I wasn't treated really well, but I still wanted to." He went silent and very angrily, to this day, I'm not sure what the anger was about, said, "Don't you ever make a phone call like this again. We may get back to you," and literally hung up the phone on me. And then a day or two later, I got a phone call from another clerk in the one of Division 4, who said, "I have a case for you, come down and get it." And then from there on, I did quite a few in all divisions, in my early days of appellate work. One of them, I'm very proud to say, ended up in the California Supreme Court, People versus Mack.
What did you learn from that experience of taking that all the way to the Supreme Court, to the California Supreme Court?
That still is one of the highlights of my career, because I was a young lawyer arguing in front of the California Supreme Court. And this was the Supreme Court I studied throughout law school. Strobrenner, Mosk, it was the Rose Bird. I know I'm taking people back. California Supreme Court. And it was a wonderful experience. It was for some reason, as many of the lawyers watching will identify, sometimes you just get into a zone where you feel very, very comfortable. And I had this give and take with Justice Strobrenner, who was like godlike to me, reading all of his opinions, where it was a search and seizure case arising from a murder. So went back and forth. I swear, it felt like at least an hour, but it probably was 5 minutes. Again, the memory playing tricks on me. But that was a wonderful experience going back and forth with him, and I just felt so comfortable. And then one more anecdotal story, I can't leave it without it, is afterwards, this was when the Court of Appeal would sit downtown in an office building on Mid-Wilshire. So we were leaving the courtroom, it was the last case, got into the elevator to go down, and there standing in the elevator was Justice Strobrenner, Mosk, and Bird.
Wow.
And the awkwardness, but I just couldn't help turning around to Justice Strobrenner in particular and saying, "That was a lot of fun." And I remember to this day his response, "That was a lot of fun for me too." That was a wonderful experience. for a young lawyer just starting out. I just got lucky to get a case all the way up there.
I love that. What else were you doing? I mean, obviously practicing your craft, but were you doing anything else proactively to get better, to develop your skills?
Well, each case sent me to the law library. In those days, it was the law library to study. And the one book I bought, the absolute best book I bought was the Legal Secretary Handbook. That taught me procedure and how to file things and everything I needed. Invaluable book, the Legal Secretary Handbook. It's a green book. I think they're still publishing it. And so and I'd go to court. And if I had a case, I would try to go early and sit and watch how it played out. Because I didn't know what I was doing. I had no one telling me what to do. I would just show up. So it was more just kind of standing back for a while, observing how it went on and how to check in. I can't tell you how many times I would go check in and the clerk would say to me, is your lawyer showing up? So I grew a mustache, hoping that would help. That didn't help in the least. And I would just watch and learn trial by error. And some judges were very helpful. Others were very intolerant. I remember one of my very, very first appearances. If I have a moment.
Yeah, please.
Yeah. Stories. Come on.
It's a lesson that I still carry with me. I had been doing pickup work. Again, I never really got a job, but I was doing ghostwriting of motions, lawn type briefs. And I did it for this one attorney. And again, in the background, his name signed. And when it came time to argue the motion, and in those days, it was a civil case, not family law case. In those days, all law and motion was done on the 8th floor of Central District, now called Mosque. The attorney called me up and said, you know, you just passed the bar, you were just sworn in, you know this case better than I. Why don't you go down and argue? You want to? I said, okay. Scared to death, I showed up. And I had never met the opposing counsel. In fact, opposing counsel did not know I even walked the face of the earth until that morning, because they have no occasion to know. And our case is called. We're standing in front of the judge, arguing the case. And this opposing counsel, whose name I still remember, but will not repeat because he still may be practicing, is arguing to the judge, and I'm standing right next to him. Your Honor, I spoke with Mr. Schwartz last night, and Mr. Schwartz said A, B, and C. Well, I'm a new lawyer. It's my first case. And my jaw dropped. And instinctively I said, Your Honor, he's lying. Well, the next thing I know, I was in the hallway, escorted out by the bailiff for calling another lawyer a liar. So he did let me back in eventually. And I've come to learn that that's the term you can't use. And unfortunately, that lawyers lie. It never crossed my mind that a lawyer would stand up there and bold-faced lie to the judge. And that has always stuck with me. I never have used in court or would never use the word lie. And that was a lesson. To this day, I don't know if the judge threw me out to teach me a lesson or he was really mad, but I don't know which it is.
Well, I guess it's a good thing you learned that lesson early on. So I want to ask you about your transition to family law, because, we've heard this morning about, or afternoon at this point, about all these different areas you were practicing, a little bit of this, a little bit of that. How did you end up exclusively narrowing down to only do family law work?
Well, in addition to doing all the other, whatever came in the door, I specialized in, and the criminal appellate work. I would walk the halls of courthouses and see if I could get conflict cases in the criminal courts. In those days, the judge, if there was two defendants, one's a public defender, and there's a second defendant, he had to appoint counsel to represent the co-defendant so that there's no conflict. And fortunately, I hooked up with a couple of judges who liked my work when they gave me a chance. So I was doing that type of work as well. So I was doing a lot of criminal work, either appellate, and sometimes if I got lucky enough to get a reversal, the family would sometimes come and hire me to handle it thereafter. It was having done that, and then I handled a case that I was well over my head, but it was a first-degree murder case. He was convicted. I got the appeal reversed and sent back for trial. And I was able to negotiate, God knows, down to second-degree murder, with the understanding that the defendant would be out in jail in about 7 years. And I remember a definitive moment. I was driving home from court going, my son was just born, thinking, I don't want this guy out in 7 years. He's a very dangerous guy. And I'm tired of going into lockups. I was tired of doing the criminal work. So I pretty much, as the practice grew, I went from Westwood, and then I ended up in Encino, where I practiced for 25 years, and phased out the criminal work and took in more as family law cases as they came. And so my family law practice grew, and thanks to a former chair of the family law section, Erwin Buter. Erwin Buter was a terrific man, and he appointed me at a rather young age to the executive committee of the LA County Bar Family Law section. And in those days, that committee was made up of superstars, not to say take anything away of who today, but just incredible superstar lawyers.
So name drop a couple and tell us a little bit about what that was like as a young attorney going into that environment.
Well, we'll start with Sorrow Trope. We'll start with Sorrow Trope, Erwin Buter, of course, Arlene Coleman Schwimmer, names are escaping, Norm Dolan, Steve Collodi, these Manly Freed. I'm drawing a blank on many of them. I would sit in Spencer Brandeis, after who the award that I'm fortunate to have received was the parliamentarian. It was an incredible group of, to my mind, it was senior attorneys, but they were all the superstar. And these gentlemen and Arlene could stand up and orate incredibly. And they were dealing with very substantive issues. It was a period when the court was starting to say, maybe we're going to go to declarations as opposed to live testimony. And that executive committee took the presiding judge on at that time, said, no, we will not do it. We will not do it. They were that influential and intimidating that the presiding judge backed down and did not start it then. But just watching these guys, I remember going home every night to press after these meetings going, I could never be like this. They were terrific.
But you did. At some point, the orchestra swells, right? And you feel like you made it. I want to segue. I can't believe how fast the time's going. I want to segue a bit into what we teased at the top, what you are most well known for, your expertise in parentage, what's called parentage now. What was the state of parentage law? You told us it was called paternity back then. In this environment, as this young lawyer really making your bones in family law?
Well, I was very lucky to be called in to work on a case the Michael H. case, which did end up in the United States Supreme Court. A friend of mine was representing, in a nutshell, I'll be very, very quick about this. It was a husband and wife who were a young couple. The husband worked in an oil company in Paris, and he would travel frequently to Paris. And when he was traveling to Paris on business, his wife Carol was traveling across the street to a boyfriend's house, Michael. So she became pregnant and did not tell Michael he may have been the father, but told Gerard, the husband, the French husband, that he was. And the long and short of it is, I was called in to help on that case. A friend was representing the mother who was doing very poorly in court. So I came in to represent Gerard, the husband, the one character in the scenario that, was the good actor. There's always good actors and bad actors in cases, and invoked the conclusive presumption, California's unique conclusive presumption, that a wife cohabiting with her husband who is neither impotent or sterile, the child born to that wife is a child of the marriage. That's California's conclusive presumption. It was in Evidence Code section 621 back in those days. It's now in 7540. In that case, so Gerard, the husband, prevailed by we invoked the conclusive presumption. We won it on summary judgment in Department 2 in front of Judge Stephen Lax. It went up to the appellate court. We was affirmed there, and it ended up in the U.S. Supreme Court on a cert. And in a plurality opinion, the constitutionality of California's conclusive presumption was affirmed as not violative of the due process rights of a man who we all recognize and almost stipulated to was the genetic father. So from that type of exposure in that case, I started to receive phone calls from other men who said, I'm not married, but I've been living with a woman for a number of years. She got pregnant, had a child. She always said it was my child, or I always believed it was my child. We're breaking up now. I've said to her, so how are we going to what will our custodial arrangement be for our son or daughter? And the wife and the girlfriend, not married, would say, what do you mean our child? And you would learn for the first time he wasn't the father. So I started to receive cases like that. In kind of figured, well, wait a minute, there must be a way for these gentlemen who believed that they were the father, established a relationship with the child, a father-child relationship, and apparently no other fathers in the picture for the moment. Now, we had some of the early days we used the estoppel, but the estoppel argument was more arose out of divorce cases where a man who was representing himself to be the child's father was trying to get out of child support obligations. They didn't fit that well in these cases, but recognize that besides the conclusive presumption, we have the rebuttable presumptions. And I don't want to, we don't have time to get into the weeds, which I will easily do, so you need to stop me. But the rebuttable presumptions are, we started to say, well, those are used and they were intended to quickly determine who a father would be, mostly by the county, the government, to assess child support. And if genetic tests proved otherwise, they would let him off the hook. But started to recognize if we could use those to make someone the father, why can't we flip it on its head and use it to affirmatively establish paternity and then move on for custodial rights? I started to make that argument, tried several cases, one of which actually an early one, Larry McClendon, they ended up making a movie about it, and still you could find it, the Larry Thicker Than Blood, the Larry McClendon story, which tells the story of how he believed he was the father of Larry Jr. She put really on the birth certificate, and then learned he wasn't, and how we fought to and prevailed to establish by the presumptions of the parentage laws in the family code that he was a father. And so
Glenn, let me jump in. So, okay, so those were two different areas that sort of developed with some of the cases that you were litigating. What about same-sex cases? How did that become part of your practice, and how were you able to use the law there?
Well, I'm very proud of that, because the law, as we know, law is a growing creature. And so we'll take a case like Larry McClendon's case, where he was found to be the father by fact that he received a child into his home and openly held this child out as his natural child. So we then started to receive phone calls from women who had children together. And in the past, there was cases that really, I always called them the picket fence cases, that would not allow same-sex couples into the courthouse, just wouldn't. So I started to use the same theory and apply it on a gender-neutral basis. And that started to catch on, and those cases slowly but surely worked their way through the court system. And there's a California Supreme Court case, Eliza B., that says you apply the presumptions in a gender neutral fashion. There was a case that I had where back in the 70s, this is show you how times has changed, a man came to me and he had helped raise a 4-year-old special needs child with his friend, platonic friend. Kevin was his name, and Kevin was a gay man back in the late, and an openly gay man at that back in the late 70s. And so he was a marvelous man and loved this special needs child, Courtney, beyond description. And for 4 years, he'd come to the home, get her ready for her special school, feed her, and the mother went off for work. And then when Courtney was 4 years old, mom just disappeared with the child, just disappeared. So we found her. We tried this case downtown. It got a lot of press because Kevin was a gay man who was asserting his parental rights to a child who he was not genetically related to. Again, using the presumptions that we've just been talking about, the rebuttable, we prevailed. And then as soon as we prevailed, the mother took off with the child and disappeared for 7 months. Finally tracked her down after the news media, a Connie Chung special. They found her, they put her off a train in Philadelphia and with the child. And the child was eventually returned to Kevin, who last I heard, everything was doing fine and mother just disappeared. But again, so these cases evolved from just the guy who wants to be, who thought he was, to same-sex couples, to even leading to same-sex adoptions. Those are relatively new. When I say relatively, I'm talking 20, 30 years ago. But before that, that would never happen.
So you were using the law as it's written in novel ways, changing how it's perceived. How did opposing counsel or bench officers react at the beginning, those initial arguments? the first few times you had to work it through the appellate system, and when did you feel like you broke through?
Well, very good question, because in the early days, I was trying these cases throughout the state, as a matter of fact, and the lawyers, opposing counsel would go, just take genetic tests, the case is over. What he's not biologically related. Why aren't we taking genetic tests? Or sometimes genetic tests were taken, and I was arguing they're not relevant. And so opposing counsel would always be confused in those days. Judges would be curious in those days, because figuring that no lawyers could be that stupid to be arguing that when it could be easily disproved. How do you even get to trial and not settle this case? But we overwhelmed the judge with the fact pattern, the relationship, how that relationship grew, developed, and was essential to the child. And so judges, I felt were sensitive to those stories that we would put on with photo albums back in those days, very emotional evidence. And then I was able to give the judge a legal, I would always call it a legal hat rack to hang their hat on. I know you want to do this, judge. Here's the legal hat rack to do it. And finally, we started to break through with some Court of Appeal opinions, affirming that a person, first one was a man who was not genetically related, was nevertheless a presumed father, thus adjudicated the father of the child. And from there, the cases started to flow. And now it's pretty common knowledge. When we raise these cases, no one says how much, but they still do, but it's easily dispelled.
So from all of your experience with these parentage cases, you ended up writing the book on parentage cases. Can you tell us a little bit about that?
Yeah, through the years, I developed a reference guide that has grown and grown and grown. That because I found that there was no good treatise on parentage, and these cases were new, and these concepts were new. So I did start to put together a booklet with these cases, and through the years it's grown. And now I lecture frequently, obviously, on this topic. To every year I do for the Judicial Council, I do their training sessions, especially for the 1058 commissioners, and they all use the book throughout the state, and I make it available. I update it every year where applicable and make it available. I think it is even material that you're giving out today, my
That's
most important edition. So I'm really proud of that book, and we work on it hard to keep it current. And we do lectures that are fun. We do fun lectures telling a lot of these stories and showing how the parentage statute fit into real life situations, the backstory. I speak Judicial Council, bar associations, any place that will have me.
So I got a couple texts, a couple notes during our program, especially in the last few minutes. And I think I can speak for the audience, and we're going to go ahead and make a ruling that you are indeed one of the parents of modern and parentage law. And I think we're going to make that official. We only have a couple minutes left, like 90 seconds. So I want to ask one last question, because your story is so compelling. What advice would you give your younger self, or really to new attorneys just starting out in family law specifically?
Well, I would give to any new attorney, no matter what they're saying, if you want to do this bad enough, you can do it. No matter what obstacles are put in your way, use those obstacles as motivation, not as deterrence. Move forward. This is all about you and doing what you want to do and the best you could do. Never settle for less for yourself. Still prepare. I still prepare for every time I go into court. I'm still a nervous wreck every time I go to court. And when you start to lose that feeling, maybe it's time not to be doing this, or you're in the wrong profession. But this is a wonderful, wonderful profession. And there's a lot of room in family law for legal scholars to think legally, to argue law. Sometimes we get so caught up in family law with emotions and things of that sort, and dividing of minimal property. Sometimes I'm not taking anything away, because there's very significant cases, but there's still always room for legal thinking and legal scholarship. And I think judges like that. I think they like that interaction where it's legal, because they come from a legal background. So if you want to do something, you could do it. Don't let anything stand in your way. Let rejection be your motivation.
Oh, Glenn, thank you so much. Unfortunately, we're out of time. We could go on for another hour or so, but we're limited here. So please, everyone, thank you for watching. Please mark your calendars and join us for our next episodes. They're all at 12:30 p.m. We have Judge Scott Gordon on April 12th, Stacey Phillips on May 3rd, and Grace Jamra and Michael Hanasab on June 7th. We want to thank Genna, Kathleen, and Belinda at the bar, the Family Law Executive Committee led by Aaron Gray and Chelsea Stevens, and our section sponsor. Again, most importantly, we thank you, Glenn, for being here and sharing so much with us and sharing your story.
And so much thank you to you guys for having me.
All right, everyone. See you next time.